Good morning, this is your Kelso Report for Wednesday, August 8th. I'm your host, Clark Kelso. We begin with the Ninth Circuit decision, where the plaintiff in Dahlia versus Rodriguez was a detective in the City of Burbank Police Department. He had disclosed the alleged use of abusive interrogation tactics by his colleagues to the Los Angeles Sheriff's Department. And 4 days later, he was placed on administrative leave. Well, that decision prompted a lawsuit against the police chief and others under Section 1983, alleging that his placement on administrative leave was unconstitutional retaliation for the exercise of his First Amendment rights. The district court dismissed the action, and the Ninth Circuit affirmed. Under binding Ninth Circuit precedent in Hubert v. City of Pittsburgh, a 2009 decision, the detective's speech was not protected by the First Amendment because the disclosure of incriminating facts is within the official duties of a police officer in the state of California. Since he was obligated by his official duties to disclose the abusive interrogation tactics, the disclosure was not a matter of free speech, but a simple matter of doing his job. Now, whether he can be placed on administrative leave for doing his job is another matter altogether. But that's not a matter of federal constitutional dimension. That's a matter of California state law. Next, we have a sovereign immunity decision. The Ninth Circuit confronted sovereign immunity issue in Al-Haramain Islamic versus Obama, which involved the United States government's terrorist surveillance program, a program that intercepted international communications into and out of the United States of persons alleged to have ties to Al-Qaeda and other terrorist networks. The district court held that the Foreign Intelligence Surveillance Act preempts or displaces the state secrets privilege, and that the government implicitly waived sovereign immunity for damages under FISA's civil liability provision, Title 50 U.S.C. Section 1810, and that two of the plaintiffs were therefore entitled to damages. Well, the Ninth Circuit easily reversed. The long-established rule is that any waiver of sovereign immunity must be unequivocally expressed. Section 1810 does not include an explicit waiver of immunity, and it is improper as a matter of law to imply such a waiver. Absent the waiver, the plaintiff's action for damages against the government must be dismissed because of sovereign immunity. If Congress wants a cause of action there, it's going to have to amend the statute. Next, the defendant in United States v. Bustamante appealed his convictions for illegal re-entry, making a false statement in a passport application, and making a false statement in an application for supplemental security income benefits. All three convictions rested on the government's allegation that the defendant was not a United States citizen. To prove that allegation, the government introduced a document appearing to be a transcription of the defendant's birth certificate from the Philippines. To be clear, it was not a copy or a facsimile of the birth certificate. Instead, it appeared to be an independent recitation of the contents of the birth certificate, and it was signed by someone purporting to be a chief civil registrar for the city of Bacolod in the Philippines. The district court admitted this evidence over the defendant's objection that, among other things, the admission of the evidence violated his rights under the Confrontation Clause. The Ninth Circuit panel held unanimously that the document was indeed a testimonial document and subject to the Confrontation Clause, because the document in essence was like an affidavit by the chief civil registrar attesting to the contents of the official birth record. A two-judge majority concluded the error was not harmless and required reversal, while a dissenting judge thought there was enough other evidence in the record to establish that the defendant was not a United States citizen. But it's the evidence holding in the case that is, of course, the interesting one. Next, The Ninth Circuit dealt with a complex issue involving minimum milk prices and the filed rate doctrine in its decision in Carlin versus Dairy America. Now, the filed rate doctrine is a judicial creation that gives federal agencies essentially exclusive jurisdiction to set rates for specified utilities, originally through rate-setting procedures that involve the filing of rates with the agencies. At its most basic, the filed rate doctrine provides that state law and some federal law, for example antitrust law, may not be used to invalidate a filed or approved rate, nor to assume that a rate would be charged other than the rate adopted by the federal agency in question. Although the product before the Ninth Circuit was milk instead of utilities, and although the rate set was only a minimum price instead of a fixed rate, the Ninth Circuit held that the filed rate doctrine applies as a general matter to minimum prices for raw milk as set by the United States Department of Agriculture under the Agricultural Marketing Agreement Act of 1937. However, in an abrupt turnaround in this case, the court then held that the filed rate doctrine did not apply to the particular facts of this case, which involved the submission of erroneous price data to the USDA and a statement by the USDA indicating it would have set different prices had the defendant reported its data correctly. Now, it does seem to me that this is a pretty big hole in the filed rate doctrine and could permit plaintiffs easily to frame their claims to avoid the doctrine's otherwise preclusive effect. So we'll have to see whether the Supreme Court takes the issue up or leaves well enough alone. After all, there is no great government interest in having minimum milk prices set based on erroneous data. Next, criminal sentencing case in United States versus Turner. The Ninth Circuit considered the interplay between criminal incarceration and civil detention of sexually dangerous persons. The defendant had completed his term of incarceration for his criminal conviction, but before his release from prison for a term of supervised release, he was further detained in prison pursuant to the automatic stay of release provisions of the Adam Walsh Child Protection and Safety Act, which sets up a process for civil commitment of sexually dangerous persons. Now, he actually was detained for 4.5 years before he received a hearing on the merits of his civil commitment under the Act. The question on appeal was whether a civil detention under the Act constitutes a term of imprisonment that both precludes and tolls the commencement of a supervised release term of a sex offender who has completed his incarceration for his criminal conviction. The usual rule is that a term of supervised release commences upon release from imprisonment, and the supervised release term is tolled only during any period in which the person is imprisoned in connection with a conviction. The Ninth Circuit held in a split decision that the 4-year detention pursuant to the Act was not a period of incarceration for a conviction, and that the period of supervised release therefore began when his formal period of incarceration ended, and the supervised release was not tolled during his civil detention. Well, the dissent makes its point in the first sentence by noting that under the majority's holding, supervised release may begin and end before a person is actually released from prison. I can imagine the result in this case catching the interest of 4 Supreme Court justices. So we'll put this one also on our watch list. And that's it for today's Kelso Report. Have a great day in the law.